right to bear arms. But are you aware that there are three meanings of this phrase? It's true. First, there's the one you all know, the right to bear arms, the one that involves carrying a gun. Then, a less common one can be evidenced by this picture of a man with furry, bare arms. That's one of my favorites. And finally, there's the right to bear arms, B-A-R-E, empty arms. I'm going to focus on one of the less familiar renditions of this phrase today, namely, the right to bear arms. Because Georgia House Bill 89, our newest concealed carry law, has ignored the right to bear empty arms, I urge legislators to significantly revise this ill-conceived piece of legislation. This bill has changed our reality into a nightmare, and it is time to let the Georgia legislature know that we want our old reality back. House Bill 89 offers the perfect opportunity to remind legislators that the right to bear arms or carry a gun is not an imperative or an absolute right. In fact, legislators must recognize the reciprocal right to B-A-R-E, bear arms. To illustrate why this faulty legislation must be amended, I will first outline the problems with this bill, including that it encourages irresponsible gun ownership, denies the rights of business owners, and ignores federal law. Then I will offer reasonable solutions to these problems with House Bill 89. House Bill 89 creates a number of problems for Georgia's citizens, and the first of these problems is that it encourages irresponsible gun ownership. Those issued permits in the state of Georgia are not required to undergo any training to carry their weapon. We can all agree that with great power comes great responsibility, right? So then why, in extending the rights of gun ownership, doesn't this bill extend the requirements of gun ownership? In an online interview with Bob Wilson of whatsgoingon.com, Alice Johnson, the founder of Georgians for Gun Safety, criticizes Georgia's outrageous lack of a training program for carry. Police officers, she states, are thoroughly trained to carry a weapon, and even 15-year-olds have to undergo a year of supervised driving before they can drive a car by themselves. Yet in Georgia, an average Joe is not required to demonstrate the capacity to shoot a gun. But even training cannot cure a moron. Let me tell you about the 53-year-old man from Aiken, South Carolina. As hilariously chronicled in an article by Karen Daly, this man actually shot himself in the leg during a firearms class. So obviously a clear background check and no history of mental illness do not account for coordination or competency to shoot a gun. Furthermore, the state encourages irresponsibility in the way it punishes violators of the bill. The bill states that while concealed carry may be allowed in certain establishments, drinking alcoholic beverages while carrying would constitute a mere misdemeanor. This can be no deterrent to forego hard liquor or a beer if you've had a hard day. In fact, this can be no law that encourages responsible gun ownership. So when it comes to House Bill 89, I prefer bear arms any day. In addition to encouraging irresponsible gun ownership, the bill's second problem is that it denies the rights of business owners. House Bill 89 pretends to protect business owners by freeing them from legal liability for the misuse of a firearm. But this bill cannot free business owners from their own personal sense of duty to their workplaces. Although the NRA states in their online fact sheet that House Bill 89 actually protects business owners because it creates no legal obligation to implement new security measures as a result of the increased presence of guns at work. But Georgia's business owners will still feel compelled to implement these measures, and they will have to fund them because this law that was passed without their input does not. In the March 2008 issue of the Iowa Law Review, author Stephanie Steins explains how these so-called parking lot laws, which allow for guns in workplace parking lots, impose, quote, substantial burdens on employers and business owners. Steins notes that the security-related costs of these laws are astronomical, Employers may feel the need to install surveillance cameras, metal detectors, or even additional bulletproofing in order to protect their employees. This sense of duty, accompanying the increased presence of guns, is also supported by hard research. Empirical evidence of workplace homicide strongly supports the fears of business owners. In a 2005 study in the American Journal of Public Health, which contacted 105 North Carolina workplaces where a worker was a homicide victim between 1994 and 1998, researchers contrasted the policies of workplaces that allowed guns and workplaces that prohibited them. The team determined that the risk of a worker being killed at work was considerably higher in workplaces with policies that allowed guns. In fact, such workplaces were 5 to 7 times more likely to be a site for workplace homicide than workplaces where guns were actually prohibited. So as a business owner under House Bill 89, I'd still prefer the right to bear arms any day. Finally, this bill fails to heed federal law. Georgia House Bill 89 is in direct violation of the OSHA General Duty Clause, as displayed on the U.S. Department of Labor's Occupational Safety and Health Administration, known as OSHA. The OSHA Act of 1970 General Duty Clause states, "Each employer shall furnish to each of his employees employment and a place of employment, which are free from recognized hazards that are causing or are likely to cause death or serious physical harm to his employees." Consequently, the DeKalb Chamber of Commerce notifies Georgians on their website that the Oklahoma bill, on which the Georgia House Bill 89 is modeled, was actually struck down by a federal court that ruled that the law violated the general duty to workplace security. Can't House Bill 89 just be expected to follow suit? When it comes to House Bill 89, I'd prefer bear arms any day. You've seen that House Bill 89 has a number of inherent problems. Fortunately, there are also a number of amendments that legislators should make to improve the bill. The policy I propose is a 4-part solution to the problems detailed above, which can be conveniently outlined using the acronym BARE for bear arms. I'm going to begin with B, base license issuance, on the passing of a concealed weapons course, and then base license maintenance on the demonstration of a person's competence to carry every single year. Clear background checks are obviously not enough in the state of Georgia. If legislators are going to base this bill on comparable bills in other states, then they should not overlook the importance of training, which, by the way, is law in Florida, Oklahoma, and South Carolina. The second revision I'm calling for is represented by A. Ascribe appropriate penalties for drinking while carrying a concealed weapon that actually match the offense. Did you know that common felonies include burglary, simple robbery, harassment, or even aiding an offender, as stated on the online lawyersource.com? Yet behavior which could actually endanger lives, like drinking while carrying a concealed weapon, is only a misdemeanor? How can such an infraction not be considered a serious crime when it should be? I say make this crime a felony and revoke licenses under evidence of such illegal behaviors by people with licenses to carry. Thirdly, R. Restore the rights of business owners to determine gun policy in their own workplaces. The Georgia Chamber of Commerce and DeKalb County Chamber of Commerce have expressed, since the bill was first created, that this bill robs business owners from their decision of if, when, and how guns may enter the workplace. Business owners deserve to have this right reinstated. So these 3 policy changes I've outlined above bring me to E. Exercise your right to be heard on this issue of House Bill 89. Encourage others all around you to talk about this reckless bill. The authors of House Bill 89 have created a bill that poses just enough problems to remind us that our natural instinct is bear arms, especially when bearing arms and carrying a gun under the law encourages irresponsible gun ownership, deprives business owners of their inherent rights, and heedlessly ignores federal law. We cannot be expected as a community to waive our values of safety, security, and individual rights so that a reckless vision of the right to bear arms may monopolize our lives. I want you to join me in signing a petition that calls for Georgia legislators to amend House Bill 89 consistent with the four-part plan I've outlined above. Because without serious amendments to House Bill 89, I'd have to say that, well, I'd prefer bear arms any day.